Yes, good evening to the aspirants of the JCJ 2022 main examination. Karibu sana in Kiswahili. In English, you are welcome to my class. And please read what I posted on the screen. Anyone can unmute and read what I posted on the screen.
Welcome to the participants of JCJ 2022 main examination. Today topic is Protection of Women from Domestic Violence Act 2005. Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, St. Augustine University of Tanzania.
Mwanza,
Manza, Tanzania, EA.
East Africa.
Okay, sir.
Yes. And you know that the protection from the domestic violence, how it can be done. Okay, now I can stop my video because there is no necessity. Okay, now come to the point of it. See, this is the Women's Protection of Women from the Domestic Violence Act of 2005. So I have taken the Srishti Kaushal, the student of Rajiv Gandhi National University of Law, Patiala, and also I have tapped some information from the Judicial Academy of the Gujarat. So these are the things. See, this is the one aspect of it. Yes. This is the Rajasthan Judicial Academy. Also, I trapped it and the courtesy from them. Now let us see the why the domestic violence. Domestic violence is sadly a reality in Indian society. A truism. In the Indian patriarchal setup, our is a patriarchal setup, not matriarchal setup. What is meant by patriarchal setup? Anyone?
Where the father...
The domination of the father's side is more. Suppose if the husband is say about a gotra of a Brahmin, or then if he married to any other caste, then automatically children should be there.
Their father's side, husband's side.
I give an example. If you suppose if a Brahmin married to a low caste woman, then the children should be there.
Belong to Brahmin's family only. Why? Because father is a cut of the family, no sir.
Children should be the Brahmins because India is a patriarchal society. Is it clear?
Yes, sir.
Children should be the Brahmins because father is
a cut of the family.
Brahmin. Patriarchal setup, that is. It is a patriarchal setup. Is it clear?
Yes, sir.
Yes, that I want to say. Again, you are saying family, head of his Karta is the family of it. Yes, no doubt, Karta is the family of it. But it's a patriarchal society, hence father, religion will come to the say fill up the blank. Children. Say.
Children.
Why you are not taking the time? Okay. So there may be many reasons for the occurrence of the domestic violence. From the feminist standpoint, it could be said that the occurrence of the domestic violence against women arises out of the patriarchal setup, the stereotyping of the gender roles, and the distribution of the power, real or perceived in society. Following such ideology, men are believed to be the stronger than women and more powerful. They control women and their lives. As a result of this power's place, they may hurt women with impunity. The role of the woman is to accept her fate and the violence employed against her meekly. In every man's success, there is a woman. In every man's disaster, there is a... Fill up the blanks. Fill up the blanks. Why you are keeping quiet? I don't know today. Did you hear my question? Say yes or no.
Yes, sir.
You heard my question. You understood my question.
Yes, sir.
For every woman, a man's success, there is a woman. For every man, disaster, there is a there is a fill up the blank. Fill up the blank. Jyoti,
Women.
Mamata Kaur, unmute and give me the answer. Unmute and give me the answer. Mamata Kaur, you have joined twice. You log out and log in. Yes. For every man, there is a woman for the success. For every woman, every disaster, there is also a woman for their disaster. The protection of the women from the Domestic Women's Violence Act, that is called the in short Domestic Violence Act, is a laudable piece of legislation that was enacted in the 2005 to tackle this problem. The act, in theory, goes a long way towards the protection of women in the domestic setup. It is the first substantial step in the direction of the vanquishing the questionable public or private distinction traditionally maintained in the law, which was being challenged by feminists time and again. Admittedly, women could earlier approach the courts under the Indian Penal Code, that is IPC, in the case of domestic violence under the article, under the section IPC, domestic violence. The woman used to tap the section of the IPC. What is the IPC section? Sir, we have forgotten, sir. If you don't know, you say pass on. If you know it, you tell me.
Sir, I don't know it's right or wrong. Section 498A.
Even though right or wrong, you say boldly.
Section 498A.
It is true. 498 capital A. That is the style of saying the Professor Hussain student. Okay, now next will come, because at the time we used to use the 498 capital A of the Indian Penal Code in the domestic violence. However, this kind of domestic violence contemplated by this act and the victim recognized by it made more expansive scope of the IPC. IPC never used the term domestic violence to refer to the objectionable practice. In fact, the only similar class of the offences addressed by the IPC dealt with the cruelty to a married woman. All other instances of domestic violence within the household had to be dealt with under the offence, and the respective acts of the violence constituted under the IPC without any regard to the gender of the victim. Yes, read this paragraph. Anyone can unmute and read.
This posed a problem, especially where the victims were children or women who were dependent on the assailant. In fact, even where the victim was the wife of the assailant and could approach the courts under Section 498 capital A of the IPC, she would presumably have to move out of her matrimonial home to ensure her safety or face further violence or retaliation. There was no measure in place to allow her to continue staying in her matrimonial home and yet raise her voice against the violence perpetrated against her. This, together with many other problems faced by women in the household, promoted this enactment, what is Domestic Violence Act.
Yes. This posed a problem, especially where the victim were the children, or where the victim were the women who were dependent on the assailant. Here, assailant means the perpetrator. In other words,
Sir,
husband
what is
or the
this
father. In fact, even where the victim was the wife of the assailant and who got it victim by the assailant, by the husband, and our husband or husband side people also. Is it clear?
Husband's relatives also, sir.
Yes. And could approach the court under the 498 capital A under the IPC. She would presumably have to move out of her main matrimonial home to ensure her safety because she cannot file a case under the 498A by staying in the same roof. That's why she goes to where?
Their mother house,
The parents' house.
parents' house.
That is the appropriate of Professor Hussain student should say. Safety or the face further violence as a retaliation. There was no measure in place to allow her to continue staying in her matrimonial home and it raise her the voice against the violence perpetrated against her by the husband or husband side people, including the mother-in-law, including the sister-in-law. This, together with many other problems faced by women in the household, prompted this enactment. Why this enactment was necessary when there is already a 498 capital A is there? So that's why it is said because there is the lacunae gaps are there, and hence this act has come into the picture to give the strength or the give the more power to the teeth of to the legislation. So, what is the Domestic Violence Act? A Domestic Violence Act, officially known as the Protection for Women from the Domestic Violence Act 2005, was brought into force by the Indian government from the October 2006. The Domestic Violence Act was originally passed by the Parliament in August 2005 and subsequently assented by the President in September of the same year, that is the 2005. In November 2007, the domestic violence was ratified by 4 of the 28 state government in India. Now, the MCQ question. What is the Act ID number? Domestic violence. Sir, we have forgotten, sir, because we read it long back. We don't know what. Sir, we don't know what we ate in the morning. How could you expect that we would understand when the exam is conducted on the 13th August? If you know it, you tell me. If you don't know, you say pasa. Participant, are you sleeping?
Passover, sir.
Say pasa. Act number 43. So, Domestic Violence Act, for the first time in the nation history, formally defined as an act of domestic violence. The definition has since been used in thousands of the court's cases, both of us, still civil and criminal cases, nature, to prosecute these individuals who commit the violent action against their spouse or loved ones. So, that is the thing. And now I will come to the another point of the study is concerned. Yeah. Then, if you happen to see the Indian society, domestic violence against a woman is not an uncommon sighting. And a plethora means excessive quality or fullness of the women face in their lives. Most of them are so accustomed to it, they don't even end up reporting it. Yet, it can be denied that many people continue to face domestic violence. In fact, the upcoming movie, what is the movie? What is the movie? What is the movie?
I don't watch movies, so I don't know.
It is there on the screen. Why you are taking that much time? It is already shown in the on the screen. Is it visible or not visible?
Visible, sir.
Then why you are not taking the time? So much time I say. What is the movie? What is the movie? What is the movie? Is anybody has seen such a movie? That movie? Say yes or no.
No.
Yes, sir. Yes, sir.
Okay, now I will show you the movie clip and you can hear the movie, what that movie says. Share. Volume movie. Yes. Where it is gone. Okay, let me close it, then I will open it, the movie. Inbox. Right. Go, 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 go. Movie is here. I don't know why it is gone. Go, go, admit. Yes. I don't know whether you could see it or not, but now I will share it. Share content. Yes, now you can enjoy the movie.
सेक्शन 9 रेस्टिट्यूशन ऑफ कॉन्जुगल राइट्स। ये लीगल नोटिस है आपको घर वापस ले जाने के लिए।
मुझे नहीं जाना है।
What's the real story? His family?
No.
He's having an affair?
No.
You're having an affair?
No.
So just one slap then.
Just a slap. पर नहीं मार सकता।
प्लीज लेट हो गया यार।
I'm not a patient. Diabetic sugar.
अरे अमू फोड़ दिया मैंने आज। You should have been there. घर तक के लिए वेट तो कर लो।
मैं स्लीपी हूँ।
मैं तो बिल्कुल स्लीपी नहीं हूँ।
उसको विश्वास नहीं था कि कंपनी चला सकता है, समझा?
Venuna. VENUNATH.
Oh यार, shit happens. होता है। More people move on.
तुम एक कंपनी में इतने इमोशनली इन्वेस्टेड थे, you could not move on। मैंने तो अपनी पूरी लाइफ इन्वेस्ट करी है तुम्हारे साथ। कैसे मूव ऑन? I don't love you।
बस यही सुनना रह गया था, बेटी डाइवोर्स करेगी।
थोड़ा हर रिश्ता फ्लॉड से जोड़ के रखना पड़ता है। बड़े कोई चीज तो मतलब टूटी हुई है।
दीदी कल इसने भेज मारी, पर कल है ना मैंने सोची किसी दिन इसने अंदर तो कुंडी लगा ली तो कहाँ जाएगी। रिश्ते बनाने में एफर्ट नहीं लगती, बहाने में लगती।
क्या करूं, हो गया ना।
ज्यादा जरूरी।
We have not met doctor for a long time.
You should give him a chance.
मुझे पता नहीं है कि कैसे he just taking the tablet ले रहे
सबसे ज्यादा नुकसान अम्मू का है, उसके ऊपर डिवोर्स का टैग लगता है। गलत तो नहीं कर रही ना?
हम तो हमेशा सही सोच के करते हैं बेटा, पर कई बार सही करके रिजल्ट हैप्पी नहीं होता।
When you're truly in love, थोड़ी बहुत मार
Generally you feel guilty or you feel giddy.
We have eyewitness testimony कि उस रात पार्टी में कोई वायलेंट एक्टिविटी नहीं आता।
अगली पिटीशन में ये भी लिखवा देना कि मैं शराबी, पागल और मैनिक डिप्रेसिव हूँ क्योंकि अभी इनकम लग रही है।
You still want to play fair?
उसने मुझे मारा पहली बार, मार सकता बस इतनी बात है। और ये पिटीशन पता उस थप्पड़ से क्या हुआ? उस एक थप्पड़ से ना मुझे वो सारी अनफेयर चीजें साफ साफ दिखने लग गई जिसको मैं अनदेखा करके मूव ऑन करती जा रही थी।
Yes, this is the movie that which I shared with you. I hope that you heard. Is it?
Yes, sir. Yes, sir.
Let me stop because it is, I think, the backward it is running.
Yes. तो हमको क्या है ना, we have to leave it.
Backward it is
हम
running.
चाहते हैं कि जो आपका शुगर है वो टाइप कंट्रोल में है, तो कंट्रोल में करने से we should aware that if that is कंट्रोल में नहीं रहेगा तो we will have the four major complications. Most common is cause of retinopathy.
Yes, now I stop.
Common is cause of cardiomyopathy. Most common is cause of gastroparesis. Most common is cause of renal problem, that is called diabetic nephropathy. And most common is cause of peripheral neuropathy.
This is coming from.
Or you should be aware. मतलब मैं डरा नहीं रहा।
Yes,
I am making you aware.
Sorry to say.
Just a minute. Let me close down that thing completely.
किडनी की तकलीफ और फूड प्रॉब्लम आता ही आता है। तो हम चाहते हैं जो भी मरीज मेरे
Yes.
और आए भी तो बहुत देर से
Where I am getting this sound?
अब मैं किडनी की बात करूँ, किडनी
close
प्रॉब्लम आज खराब हो रहा है। If you take another 20 years, लेकिन 20 years में तो आज का दिन भी तो इंक्लूड है। सही है। मैं
Okay, now
फूड की बात
it's
करता
all the
हूँ.
tabs.
Nobody talks उनका किसी ने डॉक्टर ने उनका बयान देखा भी नहीं है, आपने दिखाया भी नहीं. जरूरत नहीं पड़ती. नहीं, तो that is my duty to make you aware कि आप चेहरे से ज्यादा
Is
किसका
there
ध्यान
anybody
रखते
is
हो.
speaking?
आप एक महीना दाढ़ी नहीं बनाओगे तो चलेगा, लेकिन एक महीना आपने पेडिक्योर क्योर नहीं
Yes,
किया.
anybody is speaking there because I could hear the sound.
Advocate something name is showing here. Advocate
Yes.
SR Venu.
It's a Venunad. I think he's opened the TV. That's why I could hear all the sound. Now that I muted it that I could not see the sound now. Hear the sound. Okay, now let us come to the point. That's why I'm confusing. Why I am getting the sound from where I am getting the sound? Because I completely closed all my tabs, again opening it, but still I am getting the sound. So I found it is a Verunath who opened it, and from his house that I am getting the sound. Now I unmuted it then. Are you hearing me?
Yes, sir. Yes, sir.
Okay, okay. Now let us continue it. So you might have seen it clearly that what is dhappad. So it is a major issue that needs to be dealt with, and a woman need to realize the rights and how can they protect them. The Protection of the Women from the Domestic Act 2005 was introduced to deal with such cases. In this article, we'll understand the act of in detail. Who can file a case under this act? Against who? The complaint of the domestic violence can be filed by the aggrieved person. Section 2 of the Act defines this term. It means a woman who has been in a domestic relationship with the respondent, that a man in a domestic relationship with such a woman, and alleges that he has inflicted a domestic violence upon her. Domestic relationship refers to a relationship between the two people who live or have lived together in a shared household and are related by. How they are related by? Read the first bullet.
Marriage,
Second bullet.
a relationship in the nature of marriage, like living relationship.
Next
Third
participant.
one,
Read.
adoption.
And next participant.
Adoption
Next.
are family members.
Yes, are related through the blood relation. These are all living together under one roof. Shared household, as mentioned in this class, is the house belonging to or taken on rent by the man, means the husband or the father. The house in which a man and a woman lived together with a shared rent, and the house in which the man and woman lived along with his joint family. However, it must be mentioned here that not all live in relationship are covered under this act. There are certain requirements that must be fulfilled, and that is observed in the case of D. Veluswamy versus D. Pachiammal. Pachiammal. Patchiammal. So these are number one. Both parties must behave like a husband and wife. Number two, they must have attained the legal age of marriage. Number three, they should qualify to enter into the marriage. Number four, they must voluntarily live together in the same place for a significant amount of time. Number five, they must live together in a significant household. By married or without married? Yes? Participants?
Both, sir.
Answer is both. Because if a man and a woman living together for a longer time, the presumption is that they got married. It was also explained that if a man keeps a woman for the purpose of using her for sexual purposes and or as a servant, it would not qualify as a relationship like that of a marriage. But one thing is very much clear. If a girl or a housemaid or a servant, if she keeps only for the BBC, then we cannot say there is a relationship like a wife and a husband. Also, the section 2 defines respondent as a man. The Supreme Court in the case Sandhya Wankhed versus Manoj Bhimrao Wankhed held that the term relative, as used in the Act, has a very wide ambit, and a complaint against a female relative's of the husband or the male partners can be made within this purview. So when you say relative, that means either of course, when the spouse is there, husband's relatives. And Section 3 of the Act explains the term domestic violence in detail. It states that an act or omission will qualify as a domestic violence if it, first bullet, harms or injuries health, safety, limbs, that is the body organs, life or and mental and physical as being of a woman. Such abuse can be physical, sexual, economic, verbal or emotional by any other means. The second bullet is harm means it the harms, harasses, injures, endangers the aggrieved person to coerce her, to compel her, to force her or any of her family members to meet unlawful demands like a dowry. If the unlawful demands like a dowry, either the husband or the husband relatives or the husband mother, sisters, brothers or the father. And the last bullet says causes any other physical and mental injury to the aggrieved person, that is the woman. Types of the abuse covered by this act is, we have already discussed the 4 types of the abuse covered by this act as mentioned in it. However, these types are further explained in Bharti Ben Bipin Bhai Tamboli versus State of Gujarat. There is a case law. It is made it clear the type of the harassments are the type of the abuses. Number 1, physical abuse. Use of the physical force against a woman, such as she suffers from bodily injury or hurt, like what you have seen now, thappad, physical assault, criminal intimidation, threaten to cause hurt, and criminal force, use of force upon a person to cause him or her injury in the form of beating, kicking, punching, slapping, abandoning, and the aggrieved person in a dangerous place, making use of weapons to threaten her, forcing her to leave her matrimonial home, or hurting her children, and using physical force in sexual situations, etc. These are all comes under the
Physical abuse.
Appreciate. Now let us see the second one, sexual abuse. This is a form of physical force and includes any act in which a woman is forced to perform any unwanted or unsafe or degrading sexual activity. It includes calling her sexual names, hurting her with the objects and the weapons during the sex, and includes forced sex even by a spouse or intimate partner with whom she has consensual sex. So those are the things come under the sexual abuse. Now let us see the emotional abuse. Not all abusive relations involves the violence or the physical hurt. Many women face emotional abuse which is equally destructive. It includes verbal abuse such as yelling, name calling, blaming, isolating, intimidating, showcasing, controlling behavior, insulting, or continually criticizing her. So these are all called under the emotional abuse. Then the last type of the abuse is economic abuse. In economic abuse mainly includes a woman not being provided with enough money by her partner to maintain herself and her children through buying the clothes, food, medicines, etc. It also includes not allowing women to take up employment. Yes, it is also a economic abuse because the household expenditure is more and the woman wants that she would like to do the work. Then the husband, he goes there. When I am a man, I can save. Your contribution need not be necessary. So that approach is a wrong approach. Apart from this, forcing her out of the house where she lives by not providing her rent or depriving her of financial resources and she is entitled to under any custom or law, restricting her access to shared household also falls in this category. When he wants to share the household and restrict her not to allow in particular place, that also comes under the economic abuse. It also includes disposing or alienating her mobile or immobile assets. Whatever the mobile or immobile assets would be there of the wife, if it is disposed without the consent of her, then also it says economic abuse. And valuables, shares, securities, and other properties in which she has an interest. Whatever the property she is having, including the Sri Dhana. Is it clear?
Yes, sir.
What is meant by Sri Dhana?
The
The
property which
family will
women
give at his marriage time.
The property, the asset, the money which is given by the parents to the bride at the time of the marriage. So now the scope of the act, will you see the scope of the act was discussed in the case of the Bhartiben Bipin Bhai Tamboli versus State of Gujarat. In this case, the court said that domestic violence in India is rampant. As a daughter, as a mother, as a wife, as a sister, or a partner, or a single woman, several women face in it their lives, in some form or in the other form, every day. Yet it is the least reported form of cruelty, mainly because of social stigma and the attitude of women themselves. So naturally, very few people go to the court and report to the police because it is after a life. When the life would be there, it is a question of adjustability and adaptability. But perennial or continuous or perpetual harassment would be there, then naturally they would like to take a revolt and go to the court and see that something should come out. So, till the year 2005, the remedies available to a victim of the domestic violence were quite limited. Like we discussed, 498 capital A in the Indian Penal Code, that the cruelty by the husband or his relatives. Moreover, relationship outside the marriage were also not recognized. Such aspects forced a woman to stay silent. In regards to all this, the Parliament enacted the Protection of Women from the Domestic Violence Act 2005, and this Act provides a very wide purview to the definition of an aggrieved person, that is, includes a woman in live and in relationship. In live or in relationship, and aims to protect the woman from violence inflicted by a man and or a woman, or a spouse, or a spouse side people. Hence, the Act has a wide scope and covers a large number of the women who earlier had very limited remedies. So, the procedure involved under the Act, there are steps are given over there. Now, just throw light on the each one. The informing the production officer. So, in any institution, there would be a production officer would be there. Any person who has a reason to believe that domestic violence has been or is likely to be inflicted upon her can inform about the same to a production officer appointed under the section 8 subsection 1 of the act. It would be better if says that the production officer is a woman herself. Generally, the woman would be the production officer. Such women would be informed of her rights by the production officers, a police officers, service providers, as voluntary association registered under the law working with the objective of protecting the rights and the interest of the women, or a magistrate who has received the complaint or was present when the offense was occurred and these rights are violated. It is not only that the woman's rights should be known to the women so that the woman will lodge a complaint against if there is such a violation occurs. So the rights what the women's the agreed party the woman is having. Number one, such woman has a right to make an application if she is aggrieved, obtaining relief in the form of production order, monetary relief also, even a custody orders or residence orders or the compensation orders. When she was aggrieved by continuous abuse by the husband. Regarding the type of the abuse also we discussed. Number two, They also have a right to make use of the service provided by the available service providers. The Act itself clearly says who are the service providers who will provide such a protection to a aggrieved woman. So, by that, even a woman can approach in that manner. Number three, they also have a right to make use of the services provided by the protection officer. The protection officer also may have certain obligations on him to protect the interest of the aggrieved woman. Number four, they have a right to free legal services. Yes, if they want, they can take the legal services from the district level, national level, or even a state level legal service authority is there. They have a right to free legal service under the Legal Service Authority Act, that is 1987, which will provide the legal aid to the poor and those who could not afford to hire a counsel. So they also have a right to file a criminal case under the 498. That is, the cruelty will be shown over there. Then under the penal code, the criminal case also can be lodged against the assailant or perpetrator, that is actually the pronunciation. It must also be mentioned here that if the appointed protection officer does not perform his or her duties, he or she can be liable to imprisonment up to 1 year or fine up to 20,000. If the protection officer could not do so, even that the protection officer also come under the purview of this act, and he or she will be fined 20,000 and the imprisonment up to the 1 year. So that is the number step one. Step two is making a domestic incident reported by the protection officer. So upon the receipt of the domestic violence complaint, the protection officer must make a domestic incident report to the magistrate. Who has to report to the magistrate?
Protection officer.
Protection officer. And who will give the information to the protection officer?
The aggrieved person.
The aggrieved is the person, those who are the victim of the assailant. The report should also claim the relief for the protection order if the aggrieved person desires. Such a magistrate to whom the report is made would be magistrate of first class or the metropolitan magistrate. So the metropolitan magistrate or the magistrate of the first class should have to entertain such a case, who is exercising jurisdiction in the area of where the aggrieved person resides temporarily, where temporarily resides, and the respondent resides, or the place where the domestic violence alleged to have taken place. Generally, the jurisdiction will be given in favor of the petitioner. Who is the petitioner here?
Aggrieved person.
Aggrieved person. Or on behalf of the aggrieved person, the protection officer file a case in the court of law in front of the magistrate, who is not less than the first class magistrate or judicial magistrate, or it is a metropolitan magistrate. The copies of the report should also be forwarded to the police officer in charge of the police station within local limits in which the domestic violence allegedly took place. Apart from this, it is the duty of the protection officer to ensure that the aggrieved person gets all benefits as mentioned her rights and maintain the list of the services providers, which is clearly given in the Act, and shelter homes and medical facilities in the area for the aggrieved person. Step 3, application with the magistrate. Once an application is filed to the magistrate by the aggrieved person, someone on behalf of the aggrieved person or the protection officer, the magistrate will fix the date of the first hearing. Such a date is usually not beyond the 3 days from the date of receipt of an application by the magistrate. But the aggrieved person has given the complaint, or the police officer, the protection officer has given the complaint to the magistrate within the 3 days. It should the date of hearing should start. The magistrate will endeavor to dispose of application made within 60 days from the first hearing. If the first hearing would be there, within the 60 days, the case should be closed. Disposed. Is it clear?
Yes.
Say yes. Is it clear?
Sir.
How many days from the date of the filing the case the magistrate should make the trial?
60 days. Within 60 days, the case has to
Not
be
beyond
closed
the 3
and
days. For the first hearing, when that case will be disposed of,
within 60 days, sir.
within 60 days. Step 4, notice to the respondent. Once the date of the first hearing has been set up by the magistrate, a notice shall be given to the protection officer who shall inform the informant or any other person prescribed by the magistrate. This shall be done by the protection officer within 2 days from the date of receipt, unless an extension is given by the magistrate. To whom that the protection officer should have to give the notice?
To the respondent.
Assailant or perpetrator or the person who caused such an abuse to the aggrieved woman. Step 5. Other options that the magistrate can make use of it. Number 1. Under section 14 of this act, the magistrate may ask the respondent or aggrieved party singly or jointly to undergo the counseling with a number of service providers, such as a person must have experience in counseling. They will suggest also both of you go for the counseling. Number 2, under section 15 of the act, the magistrate can take the help of a person, preferably a woman, for discharging his function, such as a person should preferably be working in the promotion of family welfare. Yeah, they will take the help of the family welfare either in the counseling or in the disposing the case or in maintaining or in the running the case against the assailant. So that is the thing. A magistrate can take the help of a person, preferably a woman, for discharging his function. Whose function? His means magistrate function. Such as a person should preferably working in the promotion of the family welfare. So she will take the person's help who is working in the family welfare. Who? Who will take? Who will take?
The magistrate, sir.
Magistrate, it is there clearly on the screen. Why you are taking that much time? Step 6, giving orders, protection orders. If after the hearing both the parties, the magistrate is satisfied that the domestic violence took place, the magistrate can pass a protection order in favor of the aggrieved party. Such protection order restrict the respondent from number 1, coming the act of domestic violence. He should not come again the act of domestic violence in the vicinity. Number 2, abetting in the commission of domestic violence, not he should have to make an abetting also. Number 3, entering the place of employment, school, etc. of the aggrieved person. Suppose if she is the aggrieved person in a school or employee, they are not supposed to enter in the premises. Such order will be given to the magistrate. To whom? To the assailant. Number 4, attempting to communicate with the aggrieved person, trying to call her up through the mobile or by any other means, should not do it. Number 5, alienate any assets, bank accounts or lockers enjoyed either both the parties or by the respondent singly, including her Sridhana. If any other property should not be disposed over there, including the Sridhana. 6, causing the violence to any person who helped that aggrieved person or provided protection from domestic violence. Suppose either he himself or he can abet anybody person to do such a thing, should not be done by the assailant. Number 7, committing any other act which is specified in the order given. If any other act which is given in the order, then that also should be followed by the assailant, respondent. Residence order. The magistrate may also pass the residence order. Such order may, number 1, restrain the respondent from disposing or disturbing the position of the aggrieved person. Yes, the residence order also given to that respondent should not dispose where the aggrieved person is staying over there or distributing the position of the aggrieved person. Any property could not be distributed over there. Number 2, direct the respondent to remove himself from the shared household. So he want to remove that from the shared household, he should be come out and should have live separately. So that also order would be given. Restrain the respondent of any of his relative from entering the shared house If the shared house is there, they are restricting the other persons, means husband side persons or assailant side persons should not supposed to come and disturb the aggrieved person where she is residing, either if it is a household sharing also. 4. Restrain the respondent from renouncing his right in the share household. Yes, if any other share household, she cannot, the respondent cannot renounce it till, because there is a court order would be there. Number 5, restrain the respondent from disposing of the shareholder. He is not supposed to dispose the property where the assailant is staying over there. So that is the residential orders, that is. Okay? The residence order. Then we come to the monetary relief. Yes, monetary relief should be given if she is a dependent. The magistrate may also direct the respondent to pay the monetary relief to the agreed person for expenses incurred by the losses suffered by the such. Such relief may include, but is not limited to: number 1, loss of earning; number 2, medical expenses; third bullet, loss caused due to the destruction of the damage of any property; and the last bullet is maintenance for the aggrieved person and her children. What about the custody order? Custody order of whom? Children. Yes, sir, Venunath. Do you want to ask anything?
No, actually, I'm in hospital.
Mute. The magistrate may also grant the custody of a child or children to the agreed person or person making an application on her behalf. He may also specify the violation, visitation arrangement as well, in case he feels that the visitation by the respondent would be harmful to the child, or the magistrate may even refuse to allow such a visit. So if the magistrate gives the orders, because they say that the assailant would try to harm the children, or he may also try to harm the aggrieved.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We live in a world full